Very good evening, students. Good evening, everyone. So, first of all, I welcome each one of you to my class on MCQs on UP PCSJ paper 2. Let's start with my brief introduction. My name is Sandeep Khatri. These are my areas of specialization as you can see on the screen. This is the link of my profile of Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. This is the link of my Telegram channel where you can connect with me and ask your questions. And at last, I have mentioned my code, that is Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So this was about me. Now I request everyone, please be attentive, and this is going to be interactive session. This is the special law series which I have already covered in the special class. So if you are facing any of the issues in any of these laws, you can refer my special classes for that. We are already done with the explanations and the MCQs of all these acts. So I hope you are ready for the MCQs. Just one humble request, students, before answering the questions, make sure you write the question number before that. So for example, if you are answering for question number 1, numeric 1, and then whatever your answer is, A, B, C, or D. Here comes the very first question from the polity part. Which among the following amendments acts is also called as the mini constitution? 52nd, 42nd, First Amendment, 44th Amendment. Aksha, Vishal, correct answer. That is, your 42nd Amendment Act is also known as the mini constitution because of the length of this amendment. Okay. Next question. Who can dissolve the Lok Sabha prior to the completion of its tenure? Who has that power to dissolve the Lok Sabha? Choose the most appropriate answer. Students, the correct answer of question number 2. Aksha, correct answer A. President on the recommendation of Council of Ministers. So A is the correct answer. So basically the power lies in President, but this is again only on the recommendation of Council of Ministers. So you can also say indirectly the power to dissolve is in the hands of Prime Minister. But as far as this question is concerned, the correct answer is President on recommendation of Council of Ministers. Which of the following articles directs the state to protect and improve the environment? So, which of the DPSP, which article deals with the protection of environment? Shruti Verma, please do a refresh. We are on question number 3 right now. Vishal and Aksha, correct answer. That is Article 48A deals with the concept of environment. In which year did the Supreme Court declare that NJAC, National Judicial Appointments Commission, Act unconstitutional? In which year? 2010, 2013, 2015, 2018. So the collegium system still prevails, but Aksha, correct answer, that is 2015. In Supreme Court in 2015 held NJAC unconstitutional. Who can revoke national emergency? Who has that power to revoke national emergency? President, Prime Minister, Council of Ministers, none of the above. Aksha and Shruti, correct answer. Only the president has power to revoke the national emergency. Where did the concept of judicial activism originate? So, from which country is the or where origin lies of the concept of judicial activism? India, USA, Germany, Britain. Aksha, correct answer. That is USA. Now, some questions from the Indian Evidence Act. The Indian Evidence Act 1872 applied to, choose the most appropriate answer. Aksha and Shruti, correct answer. Indian Evidence Act does not apply to tribunals nor arbitrator. So the correct answer is all judicial proceedings in or before any court. Basically, this question is from the section number 1 of Indian Evidence Act. Which section of Indian Evidence Act 1872 deals only with the civil matters? Aksha, correct answer. That is section number 23. Students, when it comes to Indian Evidence Act, it applies to civil and criminal proceedings both. But there are some provisions which are exclusively for civil proceedings, and there are some provisions which are exclusively for the criminal proceedings. So, as far as your section 23 is concerned, this only deals with civil matters. Aksha and Advocate A.K. Sharma, correct answer. Section 133 of Indian Evidence Act is related to Advocate A.K. Sharma and Aksha, correct answer, that is accomplice, section 133 of Indian Evidence Act. Which one of the following is not correctly matched? Child witness, dumb witness, hostile witness, expert witness. Advocate A.K. Sharma and Aksha Chaudhary, correct answer. Dumb witness, this is basically section 119. And child witness is correct, 118. Hostile witness, 154. Expert witness is under section 45. The presumption under section 41 of Evidence Act is, choose the most appropriate option. Presumption of fact, rebuttable presumption of law, presumption of fact and law, irrebuttable presumption of law. Aksha and Advocate A.K. Sharma, correct answer. That is D. It's irrebuttable presumption of law. Basically, section 41 is also an example of conclusive proof. Now there are going to be some questions from the IPC part. Which of the following is an offense of continuing under IPC 1860? Continuing offense. Aksha Chaudhary, Advocate A.K. Sharma, correct answer. That is abduction. Abduction is one of the example of your continuing offense. Which is not an offense against the public tranquility? Assault, affray, unlawful assembly, riot. Akshay Chaudhary, correct answer. Assault is not an offense against public tranquility. But when it comes to affray, unlawful assembly, and riot, that is. Acts which come in the category of culpable homicide not amounting to murder are mentioned in which section of IPC? Aksha Chaudhary, Shubhi Khandelwal, please read the question again. A is not the correct answer. Shruti Verma, D is also not the correct answer. Acts which come in the category of culpable homicide not amounting to murder. So when we are saying culpable homicide not amounting to murder, we are saying about culpable homicide only. And when it comes to culpable homicide, it means section 299. I hope everyone is clear with this. So the answer for question number 14 is B. Done? Culpable homicide not amounting to murder is culpable homicide only. And if it says culpable homicide amounting to murder, then it is going to be section 300. Done? Next. A beats his wife. She fell down and became unconscious. Believing her to be dead and to save himself from being arrested for murder, A hanged her in the fan with rope. Postmortem report disclosed her death from hanging. He is liable for which offense? Shruti Verma, first one to answer correctly, followed by Aksha and Shubhi. AK Sharma, correct answer. It's a case of culpable homicide. Okay, by the way, can anyone tell me why culpable homicide? Anyone with the reasoning why culpable homicide? Why it is a case of culpable homicide? Shubhi, if it was a case of intention, then it will fall under section 300 clause 1, murder. There was no intention at this point of time. The reason why this is a case of culpable homicide is because A causes death. The very first essential, A is the reason who caused the death of his wife. First reason, and the second reason, A had knowledge, okay, to cause, which is likely to cause the death. Okay, so this will basically fall under 299(3). There is no 299 clause 3, but basically, we to understand the concept of culpable homicide, we divide the whole 299 into 3 parts. So this will fall under the knowledge part. Okay, I hope it's clear now. Now, some questions from the Indian Contract Act. Under Indian law, consideration may be adequate, something having some value in the eyes of law, equivalent to promise, neither A nor B. Shruti and Shubhi, correct yourself. Yes, B is the correct answer. Shruti and Aksha. Something having some value in the eyes of law. That is the correct statement. If the parties to an agreement are under a mistake as to a matter of fact essential to the agreement, what is going to be the status of that agreement? The agreement is void, the agreement is voidable, the agreement is binding between the parties, the agreement is voidable only so and so. It's a simple question, direct question. Muneshwar Singh, you have answered for question number. Student, a humble request, please do write down the question number before your answer. So, for example, if you are answering for question number 17, just write down the numeric 17 and whatever the answer you found correct. Shubhi, Pratyush, correct answer. Okay, Shruti, please do correct yourself. The agreement is void. This is because of section number 20. Okay, this whole situation will fall under section number 20. And as far as section 20 is concerned, the agreement is void. So A is the correct answer. Goods displayed in showcase of a shop with price tag is Shubhi, Lavi, correct answer, followed by Shruti, invitation to offer. Novation amounts to What is the effect of novation? What is the effect of novation? Lavi, Aksha, Shubhi, correct answer. Novation amounts to discharge of contract. Okay. Acceptance sent through post. Choose the most appropriate answer. Pratyush, read all the options. This question is basically from your section number 4. If you are clear with section number 4 of the Indian Contract Act, you can easily answer this. And only Lavi, Shubhi, and Aksha, correct answer, can be revoked before it comes to the knowledge of the offerer. So C is the correct answer. Muneshwar Singh, correct answer. Now some questions from the CPC part, students. Under Order 8, Rule 6 CPC, set off may be permitted if. Choose the most appropriate option. Pratyush and Lavi, correct answer. Set off claimed by the defendant is ascertained sum of money. You can only have a set off if that is ascertained sum of money. So that is the rule basically as per to Order 8, Rule 6. So B is the correct answer. In civil suit, the issues are framed by parties, advocate of the parties, representative of the parties, या फिर court. Who frame issues in a civil suit? Starting from Shubhi, Pratyush, Lavi, Aksha, everyone's answer is correct. That is D, court. Court is the one who is responsible for a framing of issues. And that is one of the reason that you got, at the time of your mains examination, you also got these kind of questions. Ki frame the issues of this particular, application based situation. Court of small causes under section 3 of CPC is subordinate to district court, high court, both A and B, neither A nor B. You should not take more than 2 seconds to answer this question. And if you are taking more than 2 seconds, then your jurisdiction part of CPC is not strong enough. Pratyush, Lavi, Shubhi, correct answer, both A and B. Court of small causes is subordinate to district court as well and high court as well. Which of the following section deals with the power of the Supreme Court to transfer suits? Lavi, Pratyush, and Shubhi. followed by Avantika. Everyone's answer is correct. That is section number 25. Which provision of the CPC deals with joinder of causes of action? Which provision of CPC deals with joinder of causes of action? Should be correct answer. Order 2, Rule 3. In a suit for possession by a landlord against his tenant, a subtenant is a necessary party, proper party, both A and B, none of the above. First one to answer correctly, Muneshwar Singh, followed by Aksha and Ashutosh. Pratyush as well. Correct answer. Avantika, correct answer. That is going to be proper party, not necessary party. Or both तो हो ही नहीं सकता. Either the party is going to be the necessary party or proper party. Now some questions from the transfer of property. Which of the following section of TPA deals with transfer of benefit to unborn child? Transfer of benefit to unborn child. Ashutosh, Aksha, correct answer. Avantika, Lavi. Okay, I guess everyone's answer is correct. Pratyush, section number 13. Which property cannot be transferred? Ashutosh, Avantika, Lavi, correct answer. That is all of the above. The provision relating to onerous gift have provided under which section of TPA? Ashutosh, Pratyush, Avantika, Lavi, everyone's answer is correct. That is 127. Which one of the following section of TPA deals with rule against perpetuity? Ashutosh, Pratyush, Lavi, Muneshwar, correct answer. Section number 14. A transfer of property occurring due to insolvency, forfeiture, or sale in execution of a decree is called. Choose the most appropriate option. Transfer by will, transfer by operation of law, transfer by act of the parties, none of these. Pratyush, Aksha, Ashutosh, top 3 students to answer this correctly. This is going to be known as transfer by operation of law. Why? Because when it comes to insolvency, there is going to be a liquidator who is going to be appointed. So everything will be done by the operation of law, not by the parties or any kind of will. Within the meaning of section 3 of TPA, the immovable property does not include one of the most repeated question. Section 3 is very, very important, especially when it comes to the meaning of immovable property, the definition of immovable property. So even if you have read that definition even one time, you can easily answer this question. Ashutosh, Pratyush, Avantika. Everyone's answer is correct. That is C. Does not include standing timber, growing crops, or grass. Now, some questions from the jurisprudence. Which one of the following is a legal person? Which one of the following is a legal person? Lavi, Avantika, Ashutosh, Aksha, Pratyush. Everyone's answer is correct. XYZ Corporation. According to the jurist of Analytical School, which statement is the correct one? Even if you have not read Analytical School, but if you have read the concept of customs in detail, whether in your Muslim law or Hindu law, even then you can answer this question. Aksha Chaudhary, first one to answer this correctly, followed by Ashutosh and Pratyush. Avantika, please do correct yourself. Custom becomes law. Yes. Only after its recognition by the sovereign. Okay. Now some questions from the CRPC. Classification of offences is given in CRPC under Aksha, Lavi, Ashutosh, Pratyush, correct answer. Avantika, please correct yourself. Classification of offences. This is basically section 320 is basically about compounding of offences. Okay. So the first schedule is the correct answer. A wife is not entitled to claim maintenance from her husband under section 125 if she It's okay, Avantika. You don't need to be sorry for that. Okay, Lavi, Ashutosh, Pratyush, Avantika, correct answer, all of the above. If the status of wife falls in any of these reasons, then she is not entitled for the maintenance under section 125. Which one of the following section of CRPC provides that court not to alter judgment after signing on it? court not to alter judgment after signing on it? Ashutosh, Lavi, and Avantika, top three students to answer this correctly. Section 362 deals with this concept. Who has the power to determine the language or of a subordinate court? This is not or, this is of. Language of a subordinate court. High Court, State Government, Central Government, State Government with the concurrence of the High Court. Pratyush followed by Muneshwar Singh and Ashutosh Kumar. The correct answer is State Government. Which section of CRPC provides that the High Court should be a criminal court? High Court could be a criminal court. Not should be, could be. Aksha Chaudhary, when you read section number 6, that starts with besides High Court. Okay, section number 6. Ashutosh, Pratyush, Avantika, Muneshwar, Shruti. Everyone's answer is correct. Done. If an accused pleads guilty, the judge, choose the most appropriate option, still has no discretion to convict him, has the discretion to convict him, has the discretion to convict him after recording his plea, has the discretion to convict him depending upon corroboration of evidence. See, there is no chance. See, okay, I'm reading the question. If an accused pleads guilty, the judge. If you go with option number A, this is absolutely incorrect. Still has no discretion to convict him. This is wrong. Okay, the court has all the discretion. If you read by B, has the discretion to convict him, answer is yes. This statement is correct. But has the discretion to convict him after the recording his plea, that is also correct. But the most appropriate is going to be has the discretion to convict him depending upon corroboration of evidence. Okay, so this is the most appropriate statement in comparison to C or B. Okay, so that is why D is going to be the correct answer. Okay. Now, anything which you are not clear with, you may ask questions. And if it is all clear, quickly give me a thumbs up. I'll wrap up the session. But before that, I have one important announcement for you as well. And that is, student, this is the link of my profile, my Telegram channel, and this is my code Khatri10. So let's crack PCSJ with an academy. These are the upcoming batches. This will start from January 26th, regular linking course 2023, rapid revision for Uttarakhand Judiciary starting from Feb 1, rapid revision for West Bengal Judiciary starting from January 23. Uh, Judiciary notes are coming. Okay, an academy is introducing judiciary notes as well. Okay, there is going to be subjective theory, quick view charts, recent cases and landmark judgments, legal maxims, integrated MCQs and PYQs, mains questions and model answers. And this is launching on 30th of January. Okay. You can celebrate Republic Day by getting 20% off on all your judiciary subscriptions. So this is valid till January 28 and prices are rising by 20% on January 31st. Okay. Now I am taking your questions. Ashutosh Kumar, Section 6 CRPC, please explain beside High Court means. Ashutosh, when it says besides High Court or any other court, so that beside High Court is also included in that. So High Court is also can be your criminal court. Okay. So Section 6 confirms this. So besides High Court is not, besides High Court does not mean excluding High Court. Okay. It's including High Court. Lavi, I am taking MCQs on every day. Okay. Don't worry. This is going to be in continuation. Okay, Lavi? Anything else? Okay, Ashutosh is clear with that. So there is going to be a price hike which is coming soon from Feb 1st. So do not wait. Just subscribe as soon as possible. Anything else? Lavi, you are writing time, please. Do you want to ask something? I am waiting for your comment, Lavi. Till then, if you have any other questions, you may ask. Lavi, MCQ session is going to be on regular basis. So suppose today I have taken MCQ questions on paper 2. Tomorrow you are going to have questions on paper 1. Okay. Timing is going to be 7 p.m. 7 p.m. And in addition to that, this is the link of my Telegram channel where I am going to share the link of the class as well in advance. Okay, 7 p.m. on YouTube on this same channel, Unacademy Judiciary. Okay. Chaliye ji. So on that note, thank you very much. See you in my next class. Till then, yes, it's time to say peace.